the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files, Episode 18 with Leslie Tucker, the principal of Williams, Edelstein, and Tucker, and I'm your host, Jonathan Sarr. Today's case tackles rental payment dates, but under the particular lens of working with people whose source of income stems from disability payments. Intriguing case. Leslie, take it away. What are your thoughts on this?
Yeah, thanks, Jonathan. And I think this is such a great case for people to hear about because the more I talk to clients around the country, I'm finding that so many housing providers are not aware of this type of accommodation. So the plaintiffs in this case are a married couple, both who are disabled residents at this property. They both receive SSI and SSDI, respectively, due to their individual disabilities. They both receive their check around the 3rd of each month, and they both allege that they rely on those payments to pay their rent. The property that they were living at, required that rent was due on the 1st and that there was no grace period, that it was late as of the 2nd. And as of the 2nd, you are charged late fees and, another late fee each day after that until rent is paid. So the plaintiffs made arrangements with the manager to be permitted to pay their rent on around the 5th of each month due to the date that they received their disability checks. And they went about this arrangement for about 7 years with no issue. And they made their, full rent payment each month, just a couple of days late. After rental payments were moved to a digital format through a resident portal, the previous payment arrangements that the plaintiffs had made were all of a sudden no longer recognized, and late fees started being assessed on their account. The plaintiffs requested of the kind of different manager that their previous arrangements be honored since it had worked out for so long, but the management staff allegedly would not permit them to pay rent after the date that it was specified in their lease. When the plaintiffs challenged this decision, the management company allegedly non-renewed them, and then they filed a fair housing complaint with HUD. After the complaint was filed, management ended up reversing the late fees, and then they ended up not even charging them late fees going forward. But they never got around to responding directly to their reasonable accommodation request to change their due date. Management allowed the plaintiffs to reside at the property for another 6 months, but then ended up sending them a lease termination notice due to their, aggressive stances and demands related to conciliation. This termination came while the HUD investigation was still active. HUD ended up finding that there was cause to believe that a violation had occurred, and the parties subsequently settled the matter. The company was ordered to complete fair housing training, review and revise its reasonable accommodation policy, which is all very standard in conciliations, and they also agreed to pay $10,000 in damages. Interestingly, and this is something I don't see very often, the property manager individually had his own separate settlement, and he agreed in conciliation to pay an additional $1,000 to the plaintiffs. So that was an interesting little twist to this.
Yeah, very intriguing case. Yeah, I'm with you. I'm glad that we're able to talk about this particular subject today. So thank you for the review. So, couple of questions then. So, rent is one of the most basic terms. I mean, that's the fundamental part of a lease agreement. So, how can
Mhm.
HUD require that it be altered?
Well, and I think that is, the mindset of most housing providers out there and why they aren't aware that this type of request can be a valid accommodation request.
Mm-hmm.
HUD has, been clear that altering a rent due date, or at least not assessing late fees, can be a valid request for a reasonable accommodation. And you may be expected to make that kind of accommodation if someone relies on a disability payment to pay their rent. That's really kind of the only situation or circumstance that this type of accommodation would apply.
Okay, very good. So, from the management perspective now, so just to be safe, should a manager offer this as an option for anyone who receives disability income?
No, I mean, just like any other accommodation, reasonable accommodation, the resident needs to ask for it in order for a manager to consider it as a reasonable accommodation. So, no obligation to just offer it to anyone who receives disability income. However, it is important that a manager or staff person recognize if that type of request is made. So, for example, if a resident has been assessed late fees, comes in to complain about it and says, well, my disability check doesn't come until, the 15th of the month, this isn't fair, that could certainly be and should be construed as a request for a reasonable accommodation. So it may
Mm-hmm.
not always sound like a, quote unquote request, but it certainly should be treated as one. So it's important to kind of recognize and acknowledge when those requests are made.
Yeah. Nice tip. So it's kind of like you got to tune your ears and
Mhm.
be a good active listener to a resident. So thank you for those. Thank you for those tips, and thank you again for your legal expertise and providing a nice summary about today's case and some comments. This concludes episode 18 of the Fair Housing Insiders Case Files. Thank you, Leslie, for joining us. Thank you to our awesome fair housing community. We look forward to seeing you next time. Take care, everyone.